conflicts of interest in performing your duties as a member of the committee to study regulatory change and the North Carolina State Bar. Any member of the committee who's aware of any personal conflicts or appearances thereof with respect to matters before this committee should disclose those at the meeting. We have a couple of brief agenda items before we turn to our main topic. Jeff Ward is going to be talking to us about law and technology and access to justice. He's the director of the Duke Center on Law and Technology, a topic I'm definitely very much looking forward to, and I think ties in, wonderfully with the work this committee is doing. So I'm looking forward to that. But the two small agenda items, the first is approval of the minutes from our September 2nd, 2020 meeting. I reviewed those. They look good to me. Let me pause and see if anybody has any corrections or modifications to those. And if not, does anyone want to move for approval?
Move for approval.
Second.
All right, that's moved in second. All those, you can just say aye. I don't think we need to use our voting buttons.
Aye.
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 All right. Any nays? No. If hearing none, the minutes are approved. The other thing that I wanted to do before turning to Jeff, Brian, is I know you included in our materials some of the Arizona amendments to the rules of professional conduct, in particular around legal paraprofessionals. Do you want to summarize some of the key developments out of Arizona for us?
Sure, I'll be happy to do that. So Arizona appears they saw what Utah did in creating a regulatory sandbox and a lot of opportunities for folks to test out some of these waters. And they just decided, well, we're just going to go ahead and do it. So they have amended Rule 5.4. They have created a new role within the legal profession called licensed paraprofessionals. They're kind of like the triple LTs that we saw in Washington. But it's essentially, going to be that opportunity for a different level of legal services to be licensed and provided to members of the public. With regards to 5.4, they have amended 5.4 to allow alternate business structures, essentially eliminating the prohibition on fee sharing with non-lawyers. So there's a couple of other steps that it looks like need to be taken over the course of the next couple of months. These rules aren't effective until January 1, 2021. But it looks like some folks need to, some different departments need to amend their rules and create some regulations for these different structures, business entities to operate. And they also amended their rules of professional conduct with regards to advertising. They it appears they've followed the model rules lead on making a number of different amendments. They didn't go quite as extreme as Utah did, whereby they just hacked everything and kept two rules: don't be misleading and don't be coercive. But they made some pretty big changes to their rules, and of course, as everybody hopefully knows, our proposed amendments to the North Carolina rules on advertising are currently published for comment right now. So it's going to be interesting because, like I said, they have essentially just changed their rules, and it's going to be effective starting in January. So we'll be interested to see what happens out there. I'm going over this very quickly and kind of glossing over some of the details that they have in their structure. But generally speaking, I think this will be yet another opportunity for us to observe and learn from what happens in Arizona, what steps folks take and the impact that it has on access to justice out there. But I included all those materials in your agenda, so you can take a look at some of the specific changes to the rules of professional conduct and so forth.
Thanks, Brian. No, I think that's helpful, and I was, it's pretty extensive. This new paraprofessional thing, they've got a lot of rules around it in terms of education, requirement, training, certification. So, I think very interesting model to look at, more particularly to me, and some of the, if we get to some stage where we want to do it in terms of how they drafted it and proposed it, I do think it'll be an interesting one to follow. Anybody have any questions for Brian or comments about what Arizona is doing? And again, now we got both Arizona and Utah, taking pretty dramatic strides. So I don't know what's in the water there in the Southwest, but they seem to be very interested in making some of these changes. All right. Well, if there aren't comments, and again, you can review those materials, and we'll be doing some more discussion, obviously, about limited licensure options in future meetings. I do want to turn us to the main attraction, which is Jeff Ward. Jeff serves as a director of the Duke Center on Law and Technology, where they're focusing, as we've already heard in some of our prior presentations, I do think there's real opportunity for technology to improve access to justice and change the way we think about what legal services are and how they're provided. So I think we all thought it'd be a great idea for Jeff to talk a little bit about what they are doing there and where those intersections are. So, Jeff, I think I turn it over to you, and thank you so much for taking the time to
Yes,
talk to us
thank you
today.
for letting me be here. I really appreciate it. I realize this, uh, two things strike me about this committee. One, it's not an easy committee to be on. And so I think you all need some credit for that. Even just the minutes that get sent out have a lot of attachments and a lot to read. And I understand that's a lot to do and that you're all very busy. And so to have a little bit of time with you, I really appreciate it. And hopefully I can be a little bit of a resource and talk from my areas of involvement. But I'm going to share a little bit of a presentation if you don't mind. Um, I'll start it here. Um, can everybody see that? Okay. Okay. So when I say that I'm going to share a little bit of a presentation, my goal here is to share some thoughts, but I want to make sure that the fact that I'm sharing something that I prepared doesn't keep you from shutting me up and just talking with me if you'd rather. I really don't want the priority to be what I've prepared, but really want to be a resource for you all as much as I can. So please stop me if needed. So I know we're talking about, I think what motivates this is this access gap that we're also aware of. So, I just called this crossing the access gap and wanted to highlight a couple of things about how I think we might cross that access gap. And I would call it, I hate even calling it a gap. It makes it sound subtle. I'd say the yawning gap, right? This is a major gap. It's a long, obvious failing of ours as a community, as a market, as a profession. And so when we aim to cross that, I want to propose something here, and I'm going to go over this slide in a little bit slowly, and I'm going to come back to it at the end. And if we have time, if that's what you want to talk about, this is what I think we need. I think North Carolina needs reform that is multi-pronged, justice-driven, consumer-centered, data-informed, creative, tech-aware, outcomes-oriented, which might be the most drastic change, and immediate. Um, And I wanted to put it up front because if we have the time in discussion, I'd like to talk about each of those elements and what they mean. And I think each of them will be a little bit informed by my experience with technology and innovation. I would highlight the word creative here. I could have used the word innovative. Innovative has become such a hackneyed word. I'm our associate dean for innovation and technology, and so many times it just doesn't mean anything. But I think creativity is that thing that I oftentimes is most missing, at least in law schools and sometimes from our profession. So I like to emphasize creativity. Um, in order to solve this yawning gap, as I say, I think we need a lot of things, and we need legal aid. We need service to those who can't afford it by qualified attorneys. And I know George Housen and others have spoken to you. And I mean, that's a starting point. Nothing that I'm about to say is to take away from the need to support these other means of closing the gap. And so when I say multi-pronged, I think it takes a lot. It takes pro bono. It takes those of us who are qualified and licensed and have expertise to share that expertise and to take serious that you know, a part of our profession. It takes clinics and students. And I used to direct the Startup Ventures Clinic, and before that, worked with the Community Enterprise Clinic. And all 6 of our law schools in North Carolina have clinics that provide really important service to certain communities around. And I think clinics are a wonderful way to help chip away at that yawning gap. You mentioned it before. Mark was just talking about, and Brian was giving us an update on Arizona about expanded licensees, right? So licenses for a broader range of professionals and paraprofessionals that might be able to provide services, particularly in salient areas and widely needed areas. And then I think we need innovation and technology. And this is the place where I've had the most experience. So I wanted to just emphasize that I think all these are important, but the reason you're having me today, I think, is to talk about those two. But I really want to emphasize that it's not at the expense of any of the other ones. And so we need all of that and more, I think, to close this wide gap. So a little bit on my background so you can understand my perspective. One thing that I didn't put on here, but I like to tell everybody, is I'm not a technologist. I think it's really important. Lawyers, I think, sometimes are turned away from engaging with technology discussions because they think it requires something special. If it does, then I'm really screwed. I'm out of a job because I don't have that special thing. I'm a program of liberal study, great books major with an English master's and no special technology training in my law training. But I think it's about us social thinkers and those who care about certain communities about asking the right questions. And all of us can engage with technology innovation. So I really, more than anything, want to lower the barrier and say we all can be engaged. But my background is that, I directed the Startup Ventures Clinic, so worked with a lot of entrepreneurs. They were consistently coming to us and to our clinic and saying, I'm applying such and such a technology to this existing industry, and it's going to, and they'd use words like disrupt and push forward and progress and future focused. And I was very impressed by them and very scared for myself and my students. I said, I'm not prepared to serve them well because my orientation is not theirs. I don't understand the technologies they're talking about. And as a consequence, I don't think I'm quite ready to prepare good lawyers. And so that was disruptive for me and why I moved into technology. I thought we needed to do more of it. Another is that through our center, we host a program called Duke Law by Design, where we use human-centered design principles to be very creative in rethinking the way we deliver legal services, whether it's the way we treat eviction or other issues. We have a program through our center called the Access Tech Tools Initiative, where we use human-centered design and technology to expand and supplement the services of our legal clinics. I'll talk about a couple of those examples later. We run the Duke Law Tech Lab, which just had its demo day last Friday. I'll talk a little bit about some of those teams as well, where we try to support and develop legal technologies that expand access to justice. And then my own scholarship is around these issues. So this is an article coming out in the Nevada Law Review shortly. Why Nevada? Because everything, as Mark said, is happening out west. There's something in the water. That's as close as we could get to Utah. Utah didn't offer to publish us, so so we'll take Nevada. It seems important to think about how can we be really thoughtful about what algorithms and other tools are doing and what that means for ethics and access. So my mind's here a lot. And so again, I'm excited to talk about it with you because this is what I think about before I go to bed at night. So my goals really are to provide a perspective on the role of technology and innovation in closing this gap. And that's just my perspective. And so let's chat about it. And then the way I'm going to do it is by sharing some common myths that I hear about law and technology. And so the way I've structured this is to just talk about some common myths and why I think they're wrong, why I think they're not based on data, et cetera. And I don't know, I'm going to do those in the categories of law, technology, and regulatory reform. So 3 categories of myths. And then I don't know where your Zoom screen is right now, but over on the right-hand side, in case you're covered up by people's pictures, this says discussion, and that is a very earnest invitation to interrupt me at any moment, second, et cetera, with your voice. I even asked Brian before we hopped on, I said, if somebody's trying to flag me down and I'm missing them, please interrupt me. Again, this presentation is not for me, it's for you. So ask at any point. So let's start a little bit with some stories. So 3 stories I'll share real quick, and I promise these are fast. Story number 1 is me in private practice. I worked for Latham & Watkins in Chicago, a large law firm that based at the Sears Tower, now called the Willis Tower, but I can never as a Chicagoan call it the Willis Tower, based at the Sears Tower. So I remember a certain day where we were on a floor of the Sears Tower that Latham rented or leased, and it actually had an empty conference room. There was nothing in the room except for a teleconference phone in the middle of the floor. And around the room stood 14 attorneys. 9 of them were partners from various practice areas, tax, et cetera, and 5 associates. I was one of the young associates. And we were talking to a client, a participant of a client organization, about structuring a upcoming acquisition. And we spent easily an hour, probably an hour and 15 minutes on the phone. And I remember looking around the room and thinking, as the lowest paid, the lowest hourly rate there, and knowing what my hourly rate was, looking around the room and thinking how much legal service this client was demanding for something that in the grand scheme, and I'm not trying to belittle it, but it was largely moving money around, right? From one wealthy entity to another. And at the same time, my sister was going through a divorce and custody situation in a different state. And she was struggling to pay for legal services for the most meaningful thing happening in her life, and probably the most meaningful thing that will ever happen in her life. And I remember feeling very acutely that distinction between 14 of us, highly trained, dedicated, standing around being paid by one client, versus my sister who could hardly access the help that she needed. And I'll come back to this story. Story two. Story two is when I first started teaching in a clinic at the law school at Duke. And I remember a nonprofit organization that had just started up came to us, and they needed some additional service. And we asked for their bylaws. And they handed us these bylaws that were easily 27 pages long and really clearly written for a limited liability corporation that had been slightly modified and handed over to this North Carolina nonprofit organization. And when we found out, they were desperate because nothing was working for them, not only in the bylaws, but otherwise. And they had paid $10,000, not a joke, $10,000 to a North Carolina attorney for those bylaws. And they were frustrated and they were limited in their capital to move forward. And we were able to provide services because they could no longer afford legal services otherwise. But those bylaws were inappropriate. We fixed them. We got them a nice 3-page version that was more appropriate for their workings based on actual counsel and what they needed. And we moved forward. That's story two, and I'll come back to it. And then the third story is about a friend who works in a rural North Carolina county. And this friend had spent a long time trying to build a practice, struggling to build a practice, but had some clients that he knew and depended on him. It's very hard in his particular geography to gain a new client, but it's really important that he keep clients. Well, one of his existing clients with whom he'd worked on other issues came to him and asked if he could help him form a business. And it seemed like this small business, because the person had other income, et cetera, that a limited liability corporation was right. He'd had some classes in law school. He knew a little bit about it. He really wanted to say yes to this client, but he didn't have the needs, the expertise he needed to build that capacity, at least not on hand. And as a consequence, he referred that client out to somebody else. And that person started building a relationship with another lawyer and lost some business. I'll come back to that story as well. So with those stories in mind, I'm going to talk about some myths. And these are what I would call the most pernicious myths in law, tech, and reg reform. So law myth number one should be no surprise to anybody. And this is the biggest and worst myth of all. And that's that our legal system works. It simply doesn't. Anybody who says otherwise, that's one where I'm willing to drop the gloves and fight about it. So this one I'm going to get a little bit aggressive about. And when 86% of civil legal problems reported by low-income Americans received inadequate or no legal help, this is a statistic that tends to transcend states. It's our own North Carolina inquiries, Utah's recent inquiries, national inquiries, all come up with the same level of statistics, even if they're not overly specific. But at core, we could say the vast majority of Americans have limited to no access to the law to help them solve their problems. That seems broken to me. I found compelling the first paragraph of the standing order of the Utah Supreme Court authorizing the Legal Services Innovation Office. And it says this: the access to justice crisis across the globe, the United States, and Utah has reached the breaking point. As to how affordable and accessible civil justice is to people, the 2020 World Justice Project Rules of Law Index ranks the United States 109th of 128 countries. As to that same factor, out of 37 high-income countries, the United States ranks dead last. I don't like that placement. There are no Summer Olympics this year. I didn't get to get my patriotism on. Seeing this statistic makes me also feel competitive and that we're missing out. So, but also, of course, more importantly, undermines access to justice for so many people. And then I think even worse is the kind of feeling that so many individuals have about the law. And scholars like Becky Sandifer help us to see this quite clearly in her scholarship, that ultimately individuals entitled to remedies simply do not view the legal system as an institution available to assist them. So it's not even as if they come knocking on the door. It's that there's that huge portion of the US population that simply doesn't arrive at the door, doesn't even come knocking, and doesn't even see us as a profession that can help them. To me, that's really disconcerting. Law myth number two: Legal aid and pro bono can close the gap. This is simply not true. Federal appropriation for the Legal Services Corporation is about the same that Americans spend every year on Halloween costumes for our pets. Perhaps you've heard former LSC President Jim Sandman give that statistic. He gives it quite often, and it's been true year after year. We saw this, and this was presented, I believe, last meeting for you all, that the access to justice gap in North Carolina, one legal aid attorney for almost every 8,000 of those eligible to be served, and about half of those get turned away because of lack of capacity. We have tens of thousands of people getting turned away without help for their civil legal service needs. Providing even 1 hour of attorney time to every American household facing a legal problem would cost on the order of 40 billion, and we now spend or appropriate just 3.5% of that. It's really hard for me to imagine that we're going to catch up on that other 96.5%. And then finally, I think this is really telling. Only 1/10 of 1% of annual gross revenues that the most generous law firms give to support groups that provide legal services for the poor. Only 1/10 of 1% of their annual gross revenues. Those can be some good dollar amounts, but they're still not a significant amount if you think of comparable industries or comparable giving. It seems unlikely that we're going to make this up through pro bono and legal services. Law myth number 3. People have legal problems. That's just simply not the way that people see their problems. Among low-income Americans receiving help from LSC, the most common areas relate to family, housing, and income maintenance. Even my sister, I mentioned her before, she never said to me, I'm having divorce and custody issues. She said my life is falling apart. She said my family is falling apart. She said I have uncertain income moving forward. My housing is uncertain. My daughter's school is being disrupted. Those are the things she said to me. She didn't see them as legal problems. And I think one reason I call this out as a myth, when we think about the provision of services, we think about them as legal services, and we have a defined set of something in mind we mean by legal services, but they're normally defined as what we do. That's a very circular definition. Well, what we do is legal services, but to the public, that's somewhat meaningless. They have very meaningful problems that need solution, and to them, it doesn't matter whether the person who's helpful has a degree from a law school and has passed the bar, et cetera. And as again, Becky Sandifer points out, many of these problems involve housing, employment, and healthcare, and they frequently lead to other problems, including physical illness, substance abuse, et cetera. Lucy Rica, who will be the executive director of the new Utah Legal Services Innovation Office, she often calls these public health related problems, right? Legal problems quickly merge into public health problems. And so I think this just heightens the need to see these as problems, not legal problems. Law myth number 4. The current system is good for lawyers. Okay, we just found out that it's really bad for the public, for consumers, but some people say, yeah, but it's good for lawyers. It's simply not. We have two very different legal worlds going on. I believe you may have heard from Bill Henderson already. Bill Henderson does a lot of research on what he calls a bimodal distribution of lawyering, where you have on the right-hand side of these graphs, a very narrow slice of top firms. What's interesting about them, not only is the income that these people are making, these entry-level lawyers are making, it's important. It's 160,000, it's up to I think 180,000 now as of 2020. But it's who they serve. They serve corporations. These are not lawyers who are serving individuals, except in a limited pro bono capacity. And then the very far left side, that mode over there, to use our bimodal distribution language, is actually getting wider. And we have many, many lawyers struggling to make 35,000, 45,000, and it's just a different kind of world. And they're the ones that are oftentimes serving clients. But what is the attraction for a lawyer right now to move into an area where people are underserved? Jane Reardon from Illinois' regulatory reform efforts shared this statistic. Half of the 102 counties in Illinois did not admit a single new lawyer from 2015 to 2016. I bring the statistic up. I worked at that office in Chicago, right? There were lots of lawyers. I could hardly move around without running into lawyers, but half the counties have struggled to find them, and it's a aging population without new people moving in to serve the underserved. And then to be a lawyer in most of these cases, this is from Clio, which is probably the most widely tracked billing software, can tell us that of an 8-hour workday, Lawyers on average are utilizing 2.5 hours for billable work and only collecting on 1.7 hours. 1.7 hours of collection on average a day for lawyers using their system. That is not, to me, sound like lawyers are doing super well under the current system. And so, and really raises some issues. Law myth number 5, and I'm almost done with my law myths. Current regulation ensures integrity. No, it doesn't. I'll go back to the bylaws that I spoke about before, but also this, and I think this is the more important point. Our understanding of the effectiveness of our regulatory system and legal service delivery is neither outcomes-based nor data-based. In fact, there's an extraordinary and almost embarrassing dearth of data on our industry. And there's reasons for it. We can point to confidentiality, we can point to the structure of our practice, et cetera, but the result is a lack of data. Instead, we focus on the loose proxy of who is delivering services and what entity structure they use. Neither one of those is at all a clear indication or even a meaningful indication of how that person walked away feeling with their problem was solved or that they were helped. So maybe I'll pause just for a second. I have technology myths and reg myths, but I don't want to just chatter away without getting too excited here, or while getting too excited here. Does anybody have any comments or questions on that? I promise I'll get to technology.
Jeff,
I just needed to set it up.
On the very last point, in terms of, yeah, can you hear me, Jeff?
Yep.
I can. I think on that last point around regulation, I realize we don't have a lot of data. I guess for an organization like the State Bar, obviously we look at grievance metrics in terms of how many people are complaining about behavior and, monitor compliance, when we do audits, that kind of thing. I don't know, would you consider that data driven, or are there other metrics that either other countries use or other, things that have been proposed to maybe improve the outcome-based, data aspect of regulation?
Absolutely. That's such a good question, Mark. And let me use the term A/B testing here, okay? So in order to effectively collect data on any delivery mechanism, you have to compare it to something else. Our problem is that for 100 years, we haven't been able to compare our service delivery method to anything else because we haven't allowed it. And so when I say there's a dearth of data, there's a dearth of data on the effectiveness of our solution mechanisms compared to other potential solutions. So if you're sitting, and actually Jillian Hadfield, I don't know if you've heard from her yet, but she studies not only direct-to-consumer legal services, but in-house counsel. She said in-house counsel is the best at articulating this. They say, I'm not getting what I need from legal services. We have plenty of money in the pocketbook. This is not an issue of not paying. We're not getting what we need in terms of, and the two of the things they bring up most often are project management and technology solution. We're not getting what we need, but we don't have an alternative because there's nobody else that we're allowed to go to. So in order to collect data on which is better and feed it back to our strategic management about how we should move forward and use our spend, we don't have that data. Well, the same is true here. And so the alternative, and we can talk about the UK, Australia, et cetera, but I think the best alternative that I've seen so far is Utah. They're having every alternative provider come to them to get licensed and say, here's the data we're going to provide. Here's the information we're going to collect on success, et cetera. And we can line this up over a period of trial against those other conventional and traditional service mechanisms. And we can make some informed decisions about, is it better off? Is it the same? Is it worse? Whatever it might be. So I do agree, Mark, there's obviously levels of complaint and things like that, ethics complaints, those kinds of issues, and those are really important, but there's not a meaningful metric about our service delivery versus others. Does that help?
And Mark, I had two things I wanted to say quickly. I meant to say this at the top of the hour, just when we were talking about all your transparencies. I serve on the advisory group for Jeff's Duke Law Tech Lab. So meant to mention it and forgot. The other thing I would say that we've seen so far on the presentation, the Clio slide that Jeff used that said lawyers, work fewer than 3 hours a day, 2 point something for clients. I use that slide a lot in my CLE programs to lawyers. And I can tell you solo small firm lawyers tell me all the time, those numbers are completely accurate. And they always thought it was just them. and they feel so much better knowing that they're not the only ones. So I found the Clio Legal Trends reports to be great places to look for information that really impacts solo and small firm practitioners across the state.
That's great.
I
You know what?
no, I think it's great. And I mean, we have a mix of folks both in the state bar and on this committee, but we're certainly weighted towards, I think, many larger firm lawyers, people like Todd and Colin and I that work for, large law firms. And so, and serve corporations. We're in that, company law side, not the people law side. And I find it very interesting and important to be reminded about that disparity, because what we see, like your background, Jeff, I mean, coming from a large law firm with multi-lawyer teams and, clients with $1 million legal spend, it's very different from what most lawyers are doing and what most members of the public think about when they think about legal services. So it's great to be reminded of that disparity and see that real world challenge.
And I feel like I need to remind myself too. I oftentimes think, to the earlier point about people not seeing law as helpful, I oftentimes ask myself about my reluctance to go to a lawyer. And I would do almost anything I could. I'm just being honest, this is anecdotal. I would do almost anything I could to avoid having to go and pay a lawyer to help me solve my problems. Because even my perception from the inside is it's an expensive, cumbersome, not overly consumer friendly way. So I think even anecdotally, some of this resonates with me, despite the fact that things were going quite well when I was at a large law firm in Chicago. It's just a very different feeling about the law. So please, at any point, interrupt me. I just wanted to make sure we pause there. And this is probably the more important part, because I'm here to talk about technology and innovation. I wanted to say a few things that I think are technology myths. So number one would be that technology will solve this access to justice gap. I hope I made that clear at the beginning when I said it's just part of an overall spectrum. But definitely, over time, we've had rapidly developing technology. And it didn't just happen this year. It didn't just happen this last decade. We've had emerging technologies for a long time, yet we've seen a very consistent access to justice numbers over the decades. So tech has not automatically solved anything. It hasn't done it on its own. But I do believe that with intentional intervention, shaping technology and helping technologists to see the ways that their technology can make a difference by being inclusive of different disciplines and understanding our clients and communities' real problems, we can shape that in a way that helps us get to a better result. But I do want to make sure I say from the get-go, I do not see technology as a magic salve for anything. In fact, it's likely to accrue benefits to the haves rather than the have-nots unless we intentionally intervene. Technology myth number two is the flip of that, I think, which is that people will say, but tech hasn't helped with A to J yet, therefore it probably won't. And I do want to note that the last 10 years are a significant difference in technology than years before. And people like Jeff Kelly and others I know can speak to this. We're in a different era of technology than we've ever been in before. Think about the Industrial Revolution, when finally we had machines replacing human muscle. We're finally at a place where machines can augment, supplement the human mind. And that's never been true before. And that's because we have big data and machine learning. I could mix in processing power and networks and cloud, the various components of this, but at large, it's the data and the machine learning capacities, deep learning capacities that have really arisen over the last 8 to 10 years. And all this data has allowed us to do new things with new capacities with technology that suggest to me, and the proof is going to be in the pudding moving forward, it's not there yet, but suggests to me that this is a different era for technology development, and that technology can play a role in delivering advice, delivering probabilities, decision-making, strategic ways to move forward, et cetera. Technology myth number three, I think, is this, and that's that tech-facilitated services create a second class. Here's what we mean by that, right? Let me go back for a second. We're going to have this person depend on technology when this person over here gets a real lawyer. That can seem offensive on some level, morally, ethically, et cetera, right? But I want to do a couple things. One, if you're George Housen and you say that, you have every right to say that. I just want to be really clear about this. If you've dedicated your life every day to serving those who are underserved, and you see limited license folks or whatever as potentially taking away from your already underpaid, really talented and dedicated lawyers, then yeah, you could say that I think it makes sense to be on guard against a second-class citizenship. Why not invest in the great structures we already have rather than do something new? But I think looking at legal aid is different than looking at legal tech. When we look at legal tech and we say that, 99% of the time when I hear somebody bring this up, it is a red herring meant to shut down the conversation, and it's a false dichotomy. So let me say it this way. Sorry, I'm getting ahead of myself with my slides. Normally those people think, oh, well, this technology can't do what a lawyer from Davis Polk in New York could do. Well, absolutely right. Of course it can't, right? We're not trying to do it. But the alternative is not that this person has a lawyer dedicated from Davis Polk, right? The alternative is that this person gets nothing. Look at the statistics, right? So what are we comparing it to? We're not comparing technological solutions to the best lawyers. We need to compare technological solutions to what the alternative is, and the alternative is almost invariably nothing, right? So I think that's a really, yeah, please.
It's interesting because when you said technology second class, where my mind went is people that have access to the technology versus those that don't. And now, now being in a rural county where it's very hard to find internet access reminds me of how difficult it is, both for urban populations and rural. We're seeing it with attending school, and people, say, oh, we got this great online learning, and you have huge, sections of population that can't access online earning. We may have internet solutions or things like Avo and LegalZoom that help people get resources without using lawyers, but it's only people that have internet and smartphones and other stuff. So that's a separate issue, I think, than what you meant by second class, but it does seem to be a major concern as we think about tech-enabled solutions like online dispute resolution or something. Totally. That we're enabling it for some people, but a lot of people without that technology are also going to not be able to access the new, better tech solution.
100%. I think that's front and center. In fact, I would put it as part of that prior point that it's going to accrue to the benefits of the haves and not the have-nots unless we intentionally intervene. And there are all sorts of design methodologies. They are imperfect, not always successful, et cetera, that can help with that. But there needs to be a complete awareness at all points of that, the point that you're making, Mark, which is that technology is something that we as the privileged, right? Those who, we make assumptions about how people have access to this, and they're usually wrong, right? But there has been a lot of study. There's been a lot of experience, particularly by nonprofit groups, some serving folks in this country and some other parts of the world, about how to make some of these tech solutions available more broadly. And you're not saying this, Mark, at all. I get a little concerned when some people say, well, let's not do it because not everybody could have access to it. Well, that's true, but let's pick the slice of the population that tech can, and be hyper aware of those that it misses, and also try to provide a solution in those environments. But what you said needs to be a constant reminder, I think, at all points.
Jeff, this is Cole. But even what Mark says is accurate. Everybody doesn't have it, and everybody doesn't have broadband, but almost, tremendous portion of society has access to a smartphone.
Right.
And we deliver so much information that way, even to people of very modest means often have access through that. I think right. There are ways we just have to devise systems that will allow us to deliver the services.
That's right.
Formats that are available.
And we're starting to have more and more options there, Colin. And I'll give an example in a little while. One of our Duke Law Tech Lab teams this year was called Yo Tengo Bot. And Yo Tengo Bot is in Spanish on purpose because their primary clientele are immigrants. And they have even learned how to use Facebook Messenger and WhatsApp to deliver their very sophisticated natural language processing machine learning platform in a way that's highly accessible to anybody with a smartphone. And then others, like my collaborator on many projects, Keith Picaro, has built similar tools using SMS texting. So even those who don't have a smartphone can get the responses back and forth through SMS text. And I think if you're aware of that, as you point out, we have a lot of options to deliver many of these tools, even sophisticated ones, through platforms to which people have access. But it starts with that awareness, and I think that's absolutely right. So here, just making sure that we don't assume that our starting point is that Davis Polk lawyer or that Williams and Conley. in DC, or Smith Anderson, whatever it might be, right? That's not where people are starting. People are starting at 0. And so let's make sure we compare it appropriately. You'll hear this a lot when we talk about moving from the one-to-one litigant model to the one-to-many. And this is what, so many industries have already made this leap. When we developed legal regulatory frameworks, they were because the only way of delivering services was one-to-one in the past century. But now we have the capacity to do this differently. And if I'm sitting in rural North Carolina, struggling to find clients, struggling to find ways to bring in fees, and I have the option to use a tool that's predictable, that can, in the same amount of time, I can serve multiple people, and I can therefore do it at a price point that brings people into my practice that's fair for them, I'm excited about a one-to-many model, because the alternative is normally that they don't get any services at all. I'm reminded again of that moment in the Sears Tower where, not everybody can afford a 14-to-1 services. Most people need a one-to-many. Tech myth number 4. It's legal tech versus lawyers. This is one of my least favorite myths and one of the ones that I hear the most often. It's normal. I get it. People say, oh, technology's coming in. I'm already struggling. It's just going to push me out further. It's going to be competition. It's going to be displacement. But really, I think we need to remember again our starting point. We have the most dysfunctional market of any market you can think of. It's not only where a vast majority of low income, but also over half of middle income Americans simply don't seek legal services. That's an untapped market. That's not saying we're increasing supply with a similar demand. This is about increasing demand for legal services and breaking into that market that is otherwise untapped. And I think that's really, really important for people to see. Very rarely do we point at cases and say these lawyers have been displaced. Rather, we say they've created tools that can help them bring new people into the market and expand the realm of legal services. Just a few quick examples, and I'm going to get into a few more examples here. At least Brian asked me to say, you've seen a lot of innovation. What are some of the examples? And I'll start to get into that now. One of them is through our Access Tech Tools initiative. We have a few different initiatives that I think all serve lawyers and help lawyers. So one of the first tools we created, in fact, this picture is of the tool of the students and faculty creating it. Through our Children's Education Law and Policy Clinic and our Health Justice Clinic, we have many clients who are receive denials of Social Security benefits, and they are denied the money they need for essential medicines for a time being while it goes through an appeals process. The appeals process costs the Social Security Administration a lot of money, and doctors get concerned because their patients aren't receiving the care and medicine that they need. Well, we got all 3 groups together. We said, can we build into the EPIC system some little flags that help us to know when somebody's eligible for these, helps create a report that makes it clear from the doctor that they are eligible, and then the Social Security Administration won't deny them their benefits. And the doctor said, great. The patients said, great. And the Social Security Administration said, hallelujah. It was a win-win-win for all by infusing technology into the practice. Second one, dumpster.io is a student who's created for our Environmental Law and Policy Clinic. They get data dumps put on them when they're going into litigation, and they can't find the needle in the haystack that they need right ahead of a hearing. It is simply a tool to help them better navigate in a much more user-friendly way the data that's provided to them in a very intuitive, meaningful way. It's technology that doesn't displace them. It makes them better at their job and allow them to focus on their clients. And then the last one's a tool that I created along with a faculty member from BYU in Utah, called an LLC formation tool. And this one relates to that story that I told before about the person in rural North Carolina who wanted to have an LLC, help a client form an LLC. He said, I'm not quite sure how to do it. I need a little help. Well, the LLC tool that we built that was hosted by Law Help Interactive, an LLC funded organization, in probono.net, allowed them to create new companies in multiple jurisdictions. And not only that, but provided all these helps and resources for the lawyer to guide them through. It was not meant to go to the client to navigate it on their own. It was meant to be a lawyer tool to help them navigate through and be better at serving their clients and learn in the process. And through it, it had all sorts of things the client could prepare and come and facilitate discussions with the lawyer. And it gave so many lawyers the confidence to do a new practice area that they hadn't done before. This example here is from Utah, but we made it available in, I think, 11 states by the time it was done. So that, having those kind of tools that you develop, we're starting to see how 5.4 gets in the way. think of you, like ask yourself, am I able to create these tools, or do I need to bring in outside expertise and technology expertise that could actually make my practice better? Well, sometimes that involves sharing fees, capital, whatever it might be. At least it can grease the wheels. So we have market dysfunction, limited reach, particularly for small and solo practitioners, sometimes limited referrals. That goes to the advertising and marketing. Jane Reardon often talks about her rural lawyers withering on the vine, right? Without having ways to spark their practice and reach a new clientele. Limited expertise that can be bolstered by technology tools. And then I think this is the one that people often don't talk about, but should be talked about in every sentence almost, is unpredictability. Do I want to take on, let's use expungement, right? Do I want to take on an expungement case with an antiquated data system where I have to navigate the forums and this person's probably going to pay me $75 at the end of it? Well, I don't, but you know what technology can do? Technology can streamline it and make it so I know every one of those cases takes me only 25 minutes to get the initial forms in. I can set a price at $75 and accept them every time and really start to build this into my practice. And technology tools can really not only lower prices, but enhance predictability, which is super meaningful to somebody who's billing only a limited amount of their day and spending a lot of time on marketing, client practice, employee management, et cetera. And finally, tech myth number 5, some might say this is just a money grab. Isn't technology just moving into one more industry, trying to kick out the caring professionals who abide by an ethic, et cetera? Well, I think that's very untrue in a lot of ways. One, I'll say this in a minute, we're not talking about deregulating, we're talking about re-regulating and holding technologies accountable. That's what it's about. But also, you should meet the people who are doing this. Oops, sorry, I don't know why this is going forward. Here's Simone Spence, she was our 2nd place winner in our Duke Law Tech Lab on Friday. She's been helping mothers who are owed child support navigate the system. She's a non-lawyer, but to help them navigate the system. She's written 3 books on the subject, and she's been doing it since the mid-90s. I could think of no better person who cares more about this subject than she, and she has found a way to share her expertise with a broader audience. Her mission starts from a moment of personal experience, care, and she wants to do everything she can to help people solve their problems. Same thing with People Clerk. These two founders realized how few people use small claims court in order to help solve their problems and how prohibitive it is. And they're trying to provide access to many who have justice denied. This is Jared, who works in the immigration space. I mentioned him before. He would walk down to an office in downtown Baltimore and volunteer his time pro bono to give away lots of advice. And it got to the point where the line for his services was so long, he couldn't possibly get through them. And so he said, what's a way that I can do this in a chatbot kind of triage way that actually delivers really good advice to people, but that I don't have to give up my whole practice to do this all the time. And here, this is not somebody trying to do a Benny grab. This is a former Peace Corps volunteer who cares deeply about immigration, who's trying to make people's lives better and trying to help an underserved population get the services they need. And then, of course, our founders of our winning organization, they won the $5,000 prize. I'll show that here at Friday, are these 2 young people from graduates of the University of Chicago who are creating a video analytics software to help public defenders navigate through what is cumulatively trillions of hours of body cam photo, et cetera, that can be used to help defend their clients. It is almost 3 o'clock right now, but if we have time and if you want to see more about this, I can show you a video of them. I'll skip it for now because I want to make sure we have lots of time for discussion, but I can show you their product and what they present. These are not folks making a money grab. These are people trying very hard to solve problems that they've seen firsthand that are oftentimes related to racial justice, justice denied, gender issues, all sorts of things that we care about. This is Kim Bart, Kim Bart Mulligan, who I think many of you know. After our tech lab, she was one of our judges. She said, as the access to justice gap widens, our profession needs to invest more in different ways to address unmet legal needs. New technologies promise to deliver access in creative ways that harness the energy of entrepreneurs, motivated, and this is what I think is key, by a commitment to both service and bottom line success. There's nothing wrong with trying to make a buck, but these people tend more than others to also be trying to achieve justice. I'll stop there, and then I just have a few reform myths, and they're all on one page, so that it won't take as long for me to go through them. Any questions or comments on those? Okay. If not, I'll forge ahead and then we'll save time for discussion at the end. Okay, great. So I also see some myths, some very common myths about reg reform, and these are more recent because meaningful regulatory reform has arisen only in the last couple of years as part of the more broad-spread public discussion. So what Brian and Alice and others have put together is a comprehensive set of understanding of what's going on in the United States around these topics. But let's start again with Jane Reardon. She says the three categories of rules that are in the spotlight are, number one, rules against the unauthorized practice of law. Okay, and I know every state does this a little bit differently, but that's been a common target in each state. Can we, instead of looking at the person delivering the service, look at the person or entity or whatever it is delivering the problem solution set, and can we think about licensing it? That's a new thing. Rules against lawyers providing anything of value in exchange for referrals or recommendations. And three, the rules against fee sharing with those who aren't licensed lawyers. This latter rule, ensconced in, of course, 5.4, prohibits lawyers from participating with non-lawyers as well as non-lawyer investment in firms. And we can talk about what that keeps us from doing in just a second. But arguably, the provisions of 5.4 aren't ethics rules governing lawyers' behavior vis-a-vis their clients. Instead, they're economic rules prescribing how lawyers structure their business with other lawyers and allied professionals. And as a result, there's little incentive to forgo distributions and invest in new technologies or other long-term solutions to better serve clients. And as a consequence, we're feeling legal practice. We have this sense of widespread antiquatedness, of widespread envy for other, whether it's finance or health or whatever, who've made these investments in long-term technology solutions. It can be
Can I speak to that for a minute?
Yeah, please, please.
This is Ashley Campbell. When I think I think that's such a great point. What is the incentive to be more efficient when you are billing by the hour? I mean, to me, those are two completely disparate things. And you're right, there's no incentive to be more efficient. Right. Because you're just undercutting. So why would you invest $100,000 in technology that is going to then allow you to charge less?
That's right. And one answer to that, that's such a great point, Ashley. And one answer to that is that if you do, you could license it elsewhere. So certain really savvy forward-looking firms are creating technologies that they then license. It's an alternative revenue stream for them, right? But that's very rare. And there is very limited expertise within legal practice in order to do that. And as a consequence,
what's an example of that? What do you mean? I can't picture what you're talking about.
So I can use a really proximate example, if you don't mind, which is GrowPath, which grew out of the law firm of James Scott Farron. James Scott Farron obviously is a large legal service provider for many civil legal services, and developed a technology which is an intake and client management solution for personal injury firms, and has spun off and licenses their services to others in that way. And so they created it for themselves. I've seen the technology. It's quite amazing. It's really good. They created it for themselves, but then and so it really caters to the needs of their specific industry. But then how do they justify that cost of development and creation? They don't reduce their, it's not about reducing their hours, it's about licensing that out elsewhere and expanding the revenues. But to your point, Ashley, I say that, I don't mean to, your point is so spot on. The entire model is pushing, its inertia is against innovation. And then we use these to keep out innovators in competition. And so where is our incentive to be innovative and to push the project management, the way we develop things forward?
And you can see it if it's a flat fee model, you want to be as efficient as you can be.
That's right.
Thank you.
This might be worth talking about in further discussion, and maybe it's right after I finish the reg reform stuff. But I've been talking about a little bit of a focus on smaller providers who deliver services to individuals. But the same rules, of course, apply to the large law firms where the competition is oftentimes, say, the big four, Ernst & Young, Deloitte & Touche, et cetera. And so it's worth thinking about that as well, about the way that these rules apply to them. And I'm happy to talk about that. I've done a little bit of thinking in that area and a little bit of research, but in that area, an Ernst & Young is coming in jurisdictions where it's able to provide legal services as well and say, we're providing project management of which legal services are a part. we'll quote you a flat fee for this project, and we'll use all sorts of outsourcing technology, project management tools, other professionals in order to provide what we're getting at. And it's very hard for a large law firm in the United States who's not been built on that to compete with that. Now, there are some examples of firms that are turning around, Greenberg Traurig, others, who are building now those capacities to turn around and say, we're going to build the consulting practices in order to be able to compete on that stage. But that kind of practice serving corporations deserves one kind of analysis. And I think those, as Bill Henderson helps us see, those who are underserved in the individual services deserve a different analysis. It's just that the rules as written apply to both equally, right?
Jeff, this is Heidi.
Hi,
I'm your
Heidi.
lone divorce lawyer in the group.
Great.
I'm sorry for your sister's trouble. I guess if misery loves company, she's got lots of it.
Yes.
So I have sort of two questions that are really unrelated. And one of them is perhaps born out of ignorance, and Brian might be able to answer it. But is 5.4 or something comparable to it common across all states? Yes?
Yeah, it's a model
Okay.
rule that's largely adopted in each state, but with some differences. And just so you know, sorry, Brian provided a link to a tool in previous minutes. That's the ABA. It has like a map on it. There's a website, and you can actually go into each state and see very easily what the different rules are. But it's primarily common across all state jurisdictions up until Utah and Arizona made a change.
Okay. And then sort of my second query is something and I'm in a bigger firm, although not the likes of what Mark and Colin are in. But our managing partner always says, work smarter, not harder. And then makes a joke about the younger associates seeming more capable of doing that. And I wonder how much of this is generationally driven. And that it seems like the younger generation, no offense to most of us on this call, but they do seem more geared to creative and innovative ways of doing what we've always done. And I wonder what we're doing to convey this message to younger people.
Yeah. So I was going to note education in a minute. I think it's really important. My own observations are anecdotal in the same way yours are, Heidi, and I think it's a great point. But I've seen this. Younger generations are less tolerant of us doing practice the way that we've been doing it. They're frustrated by it, and conversely, the positive way to say it, they're very enthusiastic about finding new ways and about deploying technology, et cetera. And so they're eager to. Nonetheless, they're all coming through law schools that primarily teach the same way they did in 1930. Actually quite frequently reading the same cases, the same methodology, et cetera, and doing very little on the business of law, process and practice management, technology. We could name the core set. And so they're frustrated. Let me quickly tell the story of a student that I had a few years ago who did a summer internship with a law firm in Charlotte. And when I asked him about his summer, he was telling me about something he did. They're submitting an S1 filing, securities filing. And he said, it was taking me a really long time. And so I asked him, he said, well, I wrote a Python script. And the Python script did what this very fascinating work of checking cross-references and pagination and all the little things that he was doing as a summer associate. And he said, it took me about 20 minutes to write, and it did an S1 in about 30 seconds, right? I then scanned it over just to double check with my eyes, but then I turned it into him. They said, how'd you do this so fast? He said, I wrote a script, and they said, great, here's another one. And they, over the course of the summer, he said he did a few. So I asked him, and this is the key. I said, what happened at the end of the summer before it was over? Did they ask you for the script? He said, nope. Right. And he just, to move forward. I mean, he wrote this very simple thing that literally saved hours and hours of work for a common thing that they did all the time. And they actually had no concern in even getting it from him, right? They didn't care about it. And he ended up not even becoming a lawyer. He decided, I can't suffer this, right? If they're gonna, but they cared about, to Ashley's point, billable hours, right? They just didn't have the incentive to build that in and take away the billable hours that their young associates, who are essentially doing billable hours to get trained at a young stage, they didn't have an incentive to get rid of those. But he, and his name was Marty, he had a really strong incentive to do practice differently, and found himself in a practice that didn't do it differently, and he felt frustrated. So to your generational comment, I think that's what I see the most often. They're being trained in a traditional way, they're running into traditional practices, and they're feeling less job satisfaction as a consequence, unless they can feel the agency to make a change and help things to do differently. So I think for those of us who teach at law schools and see the new generation coming up, and Jeff and others, we see students feeling like blossoming, right? When they all of a sudden get a chance to do something different. And it is an untapped, I mean, there's so much we could be doing in the law that's not only better, not more fair and just for people, but also way more fun, honestly, right? And so I feel like regulatory reform is not just about justice, it's also about excitement and renewal and reinvigoration and all that. So, and I also, Heidi, one more point. I don't think that's just for the young generation. I think they're less tolerant of it, but I think some of the people that I've seen, that LLC formation tool that I showed you before, I created that with an emeritus professor from BYU. He was in his mid 70s and just insatiably interested in doing new fun things, and found it so fun that he kept doing it. And I always learned forward thinking things from him. He was, he was older than I was, but by at least a generation, but he was really leading the way. I don't think it stops there either. I think the regulatory reform efforts that we're talking about here can be really fun for any generation. So,
Jeff, this is Colin. It seems to me that there are two kind of different camps or ideas where this regulatory reform is being looked at. One is in the business consumers that are big law folks who are in competition with the big four accounting firms and the Grant Thorntons of the world, and that are really know what they need, and they're really price focused. The other group seems like it's consumer oriented people who, one, may not know they have a legal problem, or if they have one, they're afraid to go see a lawyer because they don't think they can afford it, or they've maybe been and they have been priced out of, what it's going to cost, and so they're undertaking this on its own. But it seems like the biggest problem, it seems like the most immediate problem for us may be dealing with some of these consumers who don't know they have a problem and don't know how to address it, and how do we figure out who our market is and then develop a way to reach those people.
Yeah, I think that's really well said, and I think that's right. And let me add something to the pot that's not quite a response, an answer, but to build that a little bit. Because people don't know they have a legal problem, they do know they have a problem. And actually, almost invariably, their problems are wound up in other problems that we would consider non-legal. So Heidi probably knows this. There are many mental health and other health issues that come along with those facing family and turmoil and ends of relationships. Education issue, financial counseling is needed. Accountants and life planning, all sorts of things are wrapped up. The other way in which these fee sharing mechanisms or prohibitions come into play is they disallow multiple service providers from innovating and providing lots of multi-provider services. But yet we know, it's even intuitive, you don't have to have special training on this to know that oftentimes people need lots of kinds of services. On top of that, if we look at it from the lawyer's perspective, how do I get referrals? Well, I could be working directly with medical clinics. I could be working directly with school districts. I could be whatever it might be. It offers a lot of potential for creative business models, but we've been straight up prohibited from that for as long as we can remember, despite the fact that there have been medical legal partnerships and others that have found their ways around the rules in certain ways. It's nonetheless pretty constrained. There's only a couple business models that are allowed and nothing else. So those people that we care about, if we're really going to admit that it's a problem and not a legal problem, that it's a problem that has a legal component, then the 5.4 prohibitions make very little sense. If we were starting from ground zero, none of us would come up with that rule in order to best solve those people's problems.
Jeff, it's Steve Robertson. Can I ask you a question about a model that's been out there for a while? That would be LegalZoom. Are they a company that wants to be a law firm, or are they, and what is the success, what sort of success have they achieved both as a business model and for results that are working for the people who buy their services?
Yeah.
If you know.
Yeah, so I mean, there's a lot we could say here, and I'm glad, Steve, that you brought up LegalZoom, because particularly in North Carolina, where we've had the litigation, it looms large, right? So I will say a few things, and I've I know lots of the folks at LegalZoom, and I know them as dedicated individuals trying to put a dent in a very significant problem, et cetera. And I think largely this day, 2020, they offer something that's meaningful. They offer people, not all legal problems are the same complexity. There are things that can be done in a kind of a forms type of way, which is what they provide. That being said, I've seen some mistakes in the past. We've had people come into the clinic, the Startup Ventures Clinic, and have their founding documents that were done by LegalZoom, and they were not only wrong, but really hard to fix, quite frankly, because the person who was designated, or the entity that was designated as the, it was just hard to fix. I think that's also true, as I said before, though, of many real person legal service providers as well. So to your question, Steve, about what they want to be, I mean, clearly they've been trying to navigate unauthorized practice of law throughout their entire development. I think they've had tons of capitalization and investment, and as a consequence have been able to fight those battles and move ahead. One outcome of that, and think of it as kind of a Facebook model, they've gotten such networks effects. They're the most recognized legal service provider in the entire nation by many, by like order of magnitude versus any other legal service provider. But one of the reasons is they grew big, they grew fast, they fought it with a lot of capitalization, and they don't have much competition. So part of me says, when we look at reg reform, I don't want LegalZoom to loom too large. I don't want us to think that we're doing it for LegalZoom. I kind of like to think we're doing it for competition to LegalZoom, right? To have more people doing more innovative models, et cetera, and to have regulators who are collecting data from them that is meaningful about how they're solving people's problems. If we looked at Utah and said, how would LegalZoom have approached things under the sandbox? They wouldn't have gone in and tried to push out lawyers. They would have gone in, applied to the Supreme Court in the Innovation Office, told them what evidence they're going to provide them. All that evidence would have been downloaded to the Supreme Court and to the state bar in Utah. They would have been able to make really informed decisions. They would have been able to track it over time, compare it to other service models, et cetera, et cetera. So when I'm going to say this in a minute, it's not about deregulation, it's about re-regulation. And if we re-regulated with LegalZooms and a host of other entities in mind, we could actually benefit tremendously from them trying out these different models. But as a consequence, LegalZoom is of our current system, they've kind of had to sneak around UPL and other systems and try to withhold as much information as possible. And I don't think that's been as much to the benefit of the public as it could be. So
I hear you saying that there's limited empirical data then, really. And
because they never had to license themselves, they've been scooting around licensing rather than license themselves. There's never been a lever to pull that allows us to get the data they need. If you listen to Jillian Hatfield, Lucy Rica, John Lund, Justice Jimones, others from Utah who've pushed forward their legal services office, they will almost never say a paragraph without saying data. They always say, what is this about? This is about informing us about what good problem solution is. And we're willing to acknowledge that we don't have the right answers. And we're willing to let people try creatively. But at every turn, we're going to be collecting data and making informed outcome-based decisions based on a risk calculus about whether we allow them to move forward. We could have done the same with LegalZoom if we had a different regulatory structure put in place a long time ago. Instead, we had to ex post deal with it in the courts and just decide one way or the other. And it's probably not a super satisfactory outcome for anybody. So,
thank you.
Yeah, so I'm so glad you brought up LegalZoom. I should start the conversation with LegalZoom because that's what people think of. I'll just quickly go through my last couple of slides here about, and please interrupt me again. I think this is a really important point from Jane Reardon. It can be assumed that the goal of this regulation is to protect the public. However, there's little reason to continue to cling to a prescribed structure if enforcement results in unintended negative consequences, like limited access to justice, for consumers or lawyers. And she's really good about pointing out that this is not just for consumers, it's also better for lawyers. So let's quickly go through 6 regulatory myths. One is that law has what it needs under the current regulations. And I think we just talked about it, Heidi and others we just highlighted, there's a lack of investment capital to build these tools. There's a lack of data. There's a lack of expertise from outside the law to build technology tools, et cetera. There's a lack of diverse thinking. We all not only went through law school, but essentially the same law school curriculum. And then we're supposed to be innovative once we move into the profession. Well, what about a cognitive psychologist? What about a public policy thinker? What about engineers, et cetera? They all help us to be better, more diverse thinkers. So the current regulation really keeps out a lot of important risk capital, diversity, et cetera, from the profession. Another myth, I would say, is that reform will especially hurt solos and small firms. I alluded to it before. I actually think that it's the bigger firms that may end up having more competition, but small firms will have, I think, greater way to leverage one-to-many services, greater ways to bring in referrals and build business, ways to expand the market of that, what we always at Duke Law call the massive middle, build markets for the massive middle so that they can create demand for their services. They'll be able to do things in more predictable and cost-effective ways. They'll be able to make connections with people in the community to better serve their clients, et cetera, et cetera. I see this as being really, really potentially wonderful for solos and small firms especially. The other one, I just mentioned it, this is a call for deregulation. No, it's not. Brian mentioned at the top of the hour that Arizona is going to put a lot in place to license alternative providers. They're not saying, oh, we've rid of 5.4 or we've rid of UPL. They're saying we're going to expand the licensing structure in order to have a new way of regulating. Utah, of course, went the farthest by creating an Office of Legal Services Innovation, which is an alternative it's a new regulator in order to provide new service providers. They didn't rid of the rules of professional responsibility that apply to lawyers, but they are offering a new entryway into Utah in order to provide services. Myth 4 is that there's substantial data on both sides of this reg reform. Some others who, it's just not true. The only negative data I can point to is this, and I really mean this, and please inform me if you know of other data, is places like Australia, who started doing this in the 90s, UK and Wales, like England and Wales, who started doing this around the end of the last decade. The only significant negative data is this, that by providing alternative business models and new technology, there hasn't been a drastic reduction in access to justice gaps. I suspect two causes there. One is they're not thinking of the whole multimodal, multi-pronged approach. Of course, access to technology alone is not going to solve it. And two, the kinds of technologies that are really offering advice, offering decision-making, et cetera, are just emerging and haven't been deployed yet. And that's coupled with the fact that the markets aren't big enough for a lot of the most innovative thinkers to want to move into them. The regulation in the United States has remained so uncertain that we haven't attracted the most innovative thinkers. If you're a machine learning expert, you're going to want to move into finance and health, not into law. We need to make the regulation more attractive for innovators to move in order for us to see substantial change. But in terms of ethics complaints, UK has seen no rise in ethics complaints since they provided these alternative models. Utah, down the road, I guarantee, is just going to be more informed and have more data and be able to share those best practices widely with other states. And we're not going to see the end of ethical practice in Utah. There's just not data that suggests that this kind of regulatory move creates substantial negatives for the public. The only negative is that the access to justice piece isn't there yet. Yes.
Is there data to support that this does help with the access to justice data? I mean, I think that's one of the big questions this committee has been struggling to answer is if we want to be data driven, we want to look at the data, we identify these problems, but we haven't been able to find, maybe you can point us in that direction of somewhere where we actually can see a change and an affirmative positive. I understand that some of the negative stuff isn't out there, but where's the positive for us to say, yes, this works?
Yeah, I think, Mark, you've hit on it. That's kind of what I was alluding to there, is that I don't think there's a lot of that data out there. And here's, I think, again, why. It's that it's going to take a little bit of time for there to be an attraction into the space by innovative thinkers, for them to be some creative playing around in a complex environment that's oftentimes with multiple professionals. There's going to then need to be a consumer awareness that allows them to come in and seek out those services. And then there needs to be the tracking of the outcomes of those things over time. So in other words, we're going to need a bigger window. But I think you've hit on it, Mark. We haven't had that window yet. And we continue to have regulations in our biggest markets, Texas, California, New York, North Carolina, et cetera, that deter this kind of innovation and thinking. And you can do case studies and look and talk to innovators, and they're like, oh, heck no, I'm not moving into law. That's a landmine for me. I'd much rather use my skills elsewhere. And so until the optimistic answer for me is to say, I think you're right. There's no data, but it has to be regulatory change, at least in a sandbox way first, before you're ever going to get the innovation you need in order to make a difference with access to justice. And that, I think that's just a chicken egg issue a bit.
Do you know whether Utah or other sandbox jurisdictions have a system in place to actually measure some of that change? In other words, are they working with data analytical professor types that are actually going to be able to say, yeah, we've studied it and yeah, it works?
Absolutely. Yeah, that's right. So Utah more than, that's where I'm most familiar, but a lead economist, Jillian Hedfield, who's really been one of the people on the board of this change in Utah and continues to work with them, is analyzing this over the long term. And they're meeting with every single alternative provider when they come in to collect in a bespoke way the kind of data that they're going to need over time before they license them and what they need to continue to submit over time. And then because each one is still approved by the court, so it's, it's still, they're getting licensed in the same way licensing happens in almost every state, that the Supreme Court essentially, bestows upon that alternative provider the right to practice. All that data is coming back to a central location that shares as a database what's happening with other lawyers. So they're going to be able to track complaints versus other models, et cetera, et cetera. And so, so they're very, very conscientious about outcomes. They claim that it's a risk-based model that's outcome-based. And so they're absolutely collecting that kind of data over time. And I realize that there's resources involved in that. And I think that's really important for this group to acknowledge. If something were to be set up like this in North Carolina, I would encourage you to look to the law schools and others to try to offload some of that, because it's of much interest to us who care about access to justice. And so we could both have some academic scrutiny, but also some feedback and to the courts and to the bar. But absolutely, that's happening. And I know Jeff has his hand. I'm sorry, Colin.
That's all right. I was going to say, we had gotten some information that I think it was Oregon that did the limited license legal technicians, but it didn't get very well received. They didn't have many people that did it, and trying to figure out how to look at these things like fee splitting or non-lawyer ownership and actually measure the increase in legal services looks, on the surface, it looks pretty subjective. I don't know how we measure. We've delivered a service that otherwise would not have been delivered. It's a lot easier to measure cost savings to big business from moving your labor and employment or your tax stuff to one of these, KPMG or Deloitte than it is figuring out we're not being able to serve these people and now we are able to serve them. And how can we measure that?
Yeah, I think there's some creative ways to do that. I think you're absolutely right. We don't have good statistics on what's not being measured right now, right? So it's very hard moving forward. The Washington State triple LT situation is a little tricky because you're right, they had a small number of people go through the program. As a consequence, on a per person basis, it was very costly to administer. Part of it is that I see it as they created a space for paraprofessionals and alternative licensees, but didn't create a number of business models that would allow them to easily find work, et cetera. And so the market attraction was quite limited for people to move into the program. And so I think I would hate for anybody to jump to the conclusion that Washington's experiment was a failure and that suggests that it would happen elsewhere. I think coupled with or paired with all the other range of things that are happening, it could be a really effective part of an overall solution. There's also some accusations, and I don't mean to get in the middle of it, but that it's a highly politicized situation. And so anyway, that's only to express a little bit of caution about the Washington State experiment being a failure. I think it'll be interesting to see what happens in Utah, Arizona, New Mexico, and other places are considering similar ideas. It'll be interesting to see what happens there. Jeff, Kelly?
Yep, I'll jump in here. So not to get a little bit ahead of us, but on the question of the availability of data and really to measure some of these outcomes, the technology is pretty immature, I'd say, across the board as far as analytics go. And that's kind of my space where it is ridiculously expensive. So only your massive corporations, your sovereign wealth funds can afford to go out and collect massive amounts of litigation data and basically do enterprise risk management on it. But what I'm seeing, including in North Carolina, by the way, we are moving our kind of basic docket information online. And I suspect that as courts, especially state courts, which is where the majority of, I'd say, the access justice crisis resides, as opposed to federal dockets, as that comes online, and with court systems that are intentionally building in tools that allow us to manage or monitor some of that information, the ability to see that at sort of a feasible cost scale for access justice projects or for legal aid will become a lot better. And to kind of piggyback off of the, yes, we are looking at a little bit of an unequal distribution of the tech implementation benefiting the haves versus the have-nots. I can tell you that a lot of the work that I do with, again, like Deloitte's of the world, allows us to see the different levers and pipes in litigation systems that translate very well into solving the same problems or identifying critical information or pain points for different issues. I mean, it's something that I'm kind of trying to figure out on my own too, which is if there are specific points in a lawsuit and we now have pretty ubiquitous technology that lets us see certain events as they happen, there are ways to not even need to modify the rules of professional conduct to say, this is not commercial information. It's not for commercial purpose. This is just self-help materials, pro se litigant, that we would like for you to have, because while we can't advise you on it, this motion for summary judgment that you just had filed against you that means nothing to you, here's some things you can do to help yourself. And so I don't want to get ahead of the tech. I don't want to overpromise it, but I do think that some of the lack of data and lack of ability to say this is successful comes from the fact that these are emerging technologies. And while they could have emerged much faster with support from the bar, I think that there are a lot of brilliant people outside the profession who have been pushing it along anyway.
I think that's an excellent point. And, to start with the courts, we haven't talked a whole lot about it, but that kind of information and all the electronic information that we can bolster and make available, et cetera. The other thing this is in addition to what you just said, Jeff, when you talk to a lot of the folks who are leading the regulatory reform charge in other states, they are quick to jump to another benefit, which is long-term. And that's that the best practices, lessons, et cetera, that they learn from any particular experiment in one state can be shared broadly. So if a particular alternative provider comes to the Utah Innovation Sandbox and says, here's what we're going to do, they're going to collect quick data on that, right? And get some information. And that's data that not only can they turn around and recognize a new alternative provider that looks the same, that they know the right questions to ask, they can also share it with the whole network of other people who are experimenting in this way. I highlight it because you're going to hear me say in a second that I think there's a little bit of risk-taking warranted here. And one of the justifications for moving a little bit faster and taking risk is that I think North Carolina will benefit from being part of that massive data sharing, not just from the North Carolina state courts, but from all the other courts involved in these processes. And so we're on the verge of having a national network of reformers able to share data about best practices and what's working in their states, et cetera. And I think it behooves North Carolina to aim to be a part of that. Look at how much Utah is influencing everything right now. Who would have thought, right? Utah, it's not the most populous state. Oftentimes we look to others, for finance, New York or whatever, but Utah's leading the charge. They're looking for payback on their investment. And they'd love to share information with North Carolina if North Carolina could share something back with them. And so I think it's worth talking about all the data in courts, all the data in these regulatory reform efforts, and what kind of network effects that could create.
Jeff, just before you end today, if there is time to show your video, I think it's short. I think it's probably under 3 minutes. And I think it's a nice way for folks to see in application what we're talking about when we talk about legal tech that can help the access to justice issues.
I'd certainly be happy to share it. I walked away from the Duke Law Tech Lab on Friday feeling like the collective group sent such a good message about what legal technology could do, and it's just about 6 minutes. Would you want to watch it? Is that something? Okay, I don't want to steal all your time, but thank you, Camille, for that invitation. Let me see if I can share my computer sound It's always embarrassing when somebody talking about technology and the technology doesn't work. It's not fun for anybody. So can you see this video? It's not playing yet. And then the real trick will be is if you can hear it. So Camille, I can see you. So can you give me a thumbs up?
Hi, everyone. My name is Devshi, and I'm the CEO and co-founder of Justice Text. In 2015, I left my hometown in Southern California to attend school in the city of Chicago. As I settled in and got to know the community, I grew to fall in love with the city, its culture, its history, and its people. But as I soon came to realize, Chicago is a rather complicated place. It's the city in which 90% of police use of force incidents are against communities of color. It's also a city in which a 17-year-old unarmed African-American boy by the name of Laquan McDonald was shot 16 times by a local police officer just a year before I moved there. In the aftermath of the shooting, I saw the city government invest billions in facial recognition technology, gang databases, gunshot detection software. But time and time again, what I noticed was that these investments did very little to repair the harm that had been done to the community. And by the time I entered my senior year in college, I was angry, I was frustrated, and I was upset at the inequity so rampant in our criminal justice system. And furthermore, in a system that had become so technology dependent, there was a shocking lack of innovation built with empathy for the communities most directly impacted by it. And going into my senior year, I made a promise to myself that I would try and do something about that. The story of Justice Text began when my co-founder Leslie and I reached out to the Cook County Public Defender's Office. And speaking with them, we discovered that the criminal justice system today is being flooded with 3.3 trillion hours of surveillance footage. This includes body camera footage, interrogation videos, jail calls, and more. And in fact, 80% of criminal cases involve some form of video evidence. Now, this data can be an incredibly powerful vehicle for justice. And we have seen this in the recent tragedies of men like George Floyd and Ahmaud Arbery. Video footage played an important role in allowing their families to arrive at due process. However, to attorneys and their clients, this digital evidence means little without the tools necessary to analyze it. We've interviewed over 100 attorneys across the country and discovered that this data comes in different file formats and includes different languages and different dialects. The status quo in many public defense offices is to spend hours watching video evidence or paying incredibly high costs for human transcriptionists. In fact, we recently heard one of our customers tell us that she had been waiting 2 years to get the evidence she needed back from a human transcriptionist. And this has serious implications on the hundreds of thousands of individuals detained in our country's jails for months on end while their public defenders struggle to adequately represent them. A right guaranteed to all Americans by the 6th Amendment of the Constitution, regardless of income. Leslie and I knew that there's a much better way to extract useful insights from this data, and we were excited to use our technical background to help improve our country's criminal justice system. We spent the last 18 months building Justice Text, and we have developed an evidence management tool that generates automated transcripts of digital evidence, extracts key insights, and makes it easy for attorneys to generate clips in preparation for trial. We are currently partnering with the Duke Law Center for Science and Justice and the Harris County Public Defender's Office to improve our system's machine learning capabilities. Our ultimate goal is to automatically detect parts of the transcript where an investigator might have used aggressive or coercive speech to help criminal defense attorneys best represent their clients. Since day one, we have worked in direct collaboration with our users and have generated $12,000 in revenue through our early pilot partnerships. And we are currently piloting our platform with 3 major public defense agencies in Alameda County, Harris County, and Minnesota. which collectively serve 1.4 million low-income Americans. And in the time that we have been part of the Duke Law Tech Lab, we have made incredible progress. Just last week, we delivered a webinar to the National Association for Public Defense, where 75% of the attendees indicated that managing video evidence is a major pain point for their office. And we're just getting started. In the last 2 months alone, we have signed an additional 6 contracts with offices in Las Vegas, DC, Queens, New York, Atlanta, Cincinnati, and North Carolina, seeing a 233% increase in growth. We plan to continue expanding the scale of our impact with a tiered subscription model to our service, where offices pay for as many hours of upload they anticipate needing. And thus far, we have been incredibly fortunate to be supported by a number of incredible accelerator programs and grant-making institutions, including 500 Startups, Schmidt Futures, and of course, our very own Duke Law Tech Lab. Leslie and I first met when we were computer science students at the University of Chicago, passionate about using our technical background to advance social justice. We bring with us a wealth of experience, having previously held engineering roles at companies like Google, Microsoft, Facebook, and JP Morgan. In starting this company, we wanted to find a way to use our background to advance social justice, and we're excited to continue building towards a more equitable criminal justice system with Justice Text. Thank you.
Right. Yeah, so that was one of our teams from Friday's presentations. Like Camille said, she's on the advisory board of the Duke Law Tech Lab and oftentimes meets with teams individually and helps them. It's really a hands-on process to help them move forward. But you know, all of our teams, she mentioned the studies that she's involved in. They're all what I consider thought leaders. It's not about just grabbing a dollar. It's about really moving forward a cause that they care about. Now, that's not to say there aren't some bad actors in every industry. But for the most part, this notion of money grab or just people coming in pushing others out simply isn't true, and they're aiming to serve almost always across the board an underserved population. I know we're short on time. Let me just give my last little reg miss here. We talked about substantial data on both sides and just the lack of data on how these models compared to others. I think one myth too is that time's ripe for a study or a task force. I think time's ripe for a sandbox and to start collecting some data on actual alternative service providers. So I know that this is a committee. I understand your charge is about collecting data and not even necessarily making full proposals. So this isn't directed at you. I just think that we've seen the same problem for many decades. We have lots of opportunity to become more outcomes oriented and creative. And that I'd be very sad if 10 years from now we were talking about doing task force and studies to look at things rather than trying some things and trying to attract really innovative people here. And then the last thing is you hear this from, I think, boomer practitioners, and you also hear it from states that want to see others make mistakes first, is we can ride this out. I think it's unfortunate when the people who are most esteemed in our profession, those who are with a lot of experience and those who really understand the integrity of the legal profession, send the signal to younger lawyers that there's no need for change. I think it's a moral duty, to be frank, for all of us to close the access to justice gap. And so, to Heidi's point earlier, I thought it was such an astute question to ask about generation shift. I don't think anybody can ride this out. I think it's quite to the contrary. We now have tools and we now have data. We now have things that can make a difference. Let's make the law better. And in terms of North Carolina writing it out, I think we missed some opportunities if we don't become one of the states that's intimately engaged in this, a participant in the conversations and the discourse, an attraction to some of the innovators. Our economy, our legal services, our bar will suffer if we don't take the opportunity to be a leader in this way. And so I know that those last two myths are a lot of Jeff and not so much based on data. Those are my own sentiments, but wanted to share them anyway. So again, legal aid, pro bono clinics, licensees, innovation, technology, all that. I also think education is a key part of that all along the way. We do things like Duke Law Next, by Design, Access Tech Tools Initiative. We have a current derby going on looking at this issue with participants from Wake Forest, North Carolina Central and Duke Law School with our students trying to infuse this creative design. But more schools need to be doing this. More students need a chance to do this in order to make the law better later. But luckily we have a very supportive dean, seeing innovation and technology as core to our mission. And then the last thing I'll mention before we just talk a little bit more is that there's this great report that came out this week called Civil Justice for All. I can make sure, or Brian or somebody else can make sure we have the link, but they came up with a few key recommendations. And one is regulatory changes to allow non-lawyer citizen justice advocates, more collaboration between law and other professions, and better adoption of effective technologies. So we keep hearing the same messages over and over again. There is lots of data on this side and not a whole lot of contrary data. So we keep hearing it again and again. So I'll end where we began, which is that I think North Carolina needs reform that is multi-pronged across that whole board, justice-driven, consumer-centered, data-informed, creative, tech-aware, outcomes-oriented, and I would say immediate. Waiting is just that many more tens of thousands who will go without having their justice demands met. So I will stop there and maybe we can talk a little bit more.
Jeff, thank you so much. I really appreciate your presentation, and you covered a tremendous amount. I gave up trying to take notes at some point because we were moving so quickly. So hopefully we can get your slides.
Absolutely.
To help preserve some of what you've shared with us.
Well, I apologize if I move too quickly, Alice, but always happy to keep the conversation going. So.
Well, thank you. And thank you for the challenge that you offered there at the end. It is really quite a challenge because of the way we regulate in North Carolina and the extent to which we are a creature of the General Assembly, the legislature. So that creates some really unique barriers and barriers to possibly doing a sandbox or anything of that nature. But and I hear what you're saying, but I think we need to have a better idea of what's out there and what's being proposed before we launch in because
Totally.
of those barriers.
No, I think you're doing great stuff. I'm so happy that this committee exists, one, that you're seeking data and seeking inspiration and seeking best practices from other states. That was not to criticize this committee, but it is to say that, we've had task forces on access to justice coming from the courts and elsewhere for many, many years. I remember reading about them when I was a law student and seeing that gap not close. So, whatever happens moving forward, that's not about this committee, but whatever the mechanisms are, I just think it would be a shame if we, 10 years from now, we're meeting on whatever the equivalent of Zoom is, or maybe even in person. How about that? And talking about the same issues. There's a little more urgency than I think many lawyers acknowledge. And it's especially hard for us lawyers where things are going well, right? If we are duly employed and feeling really busy, it's hard to feel compelled to modify the structure of which we are a part. And that's a challenge for me too. I just like to remind us that every minute we wait is kind of like a wrongful conviction. There's somebody sitting in jail and not having justice. Every minute we wait, there's somebody else who's dealing with a key family law or eviction or other issue that's not really getting the services they need. And so that's part of the moral compulsion for me. So.
Jeff, I have a question. One of the things that you said at the very beginning, which is just sort of stuck with me, was the startling and fairly depressing statistic about where the United States ranks in terms of access to justice, both globally and within what we would consider, countries more on our level. We keep talking about Utah and some things that other states have done. Is there data, I guess our new favorite word, on what distinguishes other countries' success in terms of access to justice versus ours, or something that we could look at that would suggest it's in the regulation or regulatory reform, or what puts them ahead of us?
It's a great question, Heidi. And one, I just want you to let you know, anytime you want Jeff Kelly to smile, just say data. It worked that time. So see, it worked again. So yes, there's data in a couple of ways. So there are rule of law indices that oftentimes include access to courts and access to legal problem resolution as part of that rule of law. So these are oftentimes wrapped up in a host of other concerns like trust in government entities, et cetera, that so it can be hard to extricate meaningful data there. But there are some nice comparisons that happen. So for instance, Brazil, one of our teams working right now on the legal design derby that I mentioned is a group of students from around the world, and a couple of them are from Brazil. And they say, well, we get a lawyer if we have a civil legal need, right? And so there's certain structures that you can point to and just quickly identify why things are different in those structures. Then things get more nuanced because you have the ways that fees are collected. So for instance, you have loser pays systems. You have, those kinds of mean a lot. You have different rules around contingent fees. All those kinds of things make it different. And then they get really, really different when you move into civil and common law systems, where judges play a different role in bringing evidence and the different costs of trial and all that. So it's really hard to do too much apples to apples comparison with other countries. But probably then there's another range of things that have happened, which is that Australia, the two most notable, I think, are Australia and England, Wales, that have provided for alternative business service providers that have been licensed in essentially an alternative way than just a lawyer. And the clear evidence is that there has not been an uptick in ethics complaints. But to Mark's point earlier, there's also not clear evidence that they have very substantially reduced the gap in access to legal services. So I think it's worth looking more. I'm no expert in this area. People who I've mentioned before, like Jillian Hadfield or Rebecca Sandifer or Bill Henderson or other scholars in this area might have more information, but it's something that I think any of us wouldn't mind helping to rustle up if that's an area of inquiry that you're looking into.
I have a comment and a question for Jeff as well, if that's okay. So the comment is this, and this is really for the group. Jeff, I want to say just thank you so much for what I think of. First of all, it was a terrific presentation today. I could listen to you for 2 more hours, but also it's really a call to action for all of us. And Jeff just said something that really resonates with me, which is that it's those of us who are in the legal services community who are dealing with people day in and day out who we are unable to serve because of lack of resources, who really are able to see this problem on the front lines. And, those of us in law firms, so I'm in both, I straddle both, and I'll talk just a minute about what that looks like for me. But then for those of us in law firms who have paying clients, who we just don't see this day to day. We don't have people calling us regularly who we turn away because they can't afford us. We just don't have that day-to-day experience. And so it's just so important that when we're putting together groups like this, and that we're looking at who should be on the State Bar Council to represent North Carolina, that we make sure we have representatives from the legal services community and these underserved communities to be a voice in that larger group. And just so for those of you who I don't know as well, I started out as a legal aid lawyer. I worked at the legislature, and then I worked at a mid-sized law firm with about 22 lawyers in Raleigh, and now I'm back in a clinic at Campbell Law School. So I've been in both realms. I understand the issues and concerns from both. And it's just so important for us to be listening to the voices of people on the front lines who are regularly turning away clients to understand the magnitude of the problem. Jeff, so I just had a follow-up question for you. We talked earlier about how there's really little incentive for law firms potentially to innovate because we bill by the hour. But there is incentives for folks who are providing pro bono services, clinical services, and legal services through legal aid programs to innovate, right? So are you aware of any legal services programs in the United States who have really used technology effectively as a means of delivering legal services to more clients?
Yeah, absolutely. And there are probably others like Camille and Jeff and others who can answer this to some degree. So the Legal Services Corporation hosts a conference each year. It's usually in January. And that's actually one of the best places to go to find a one-stop shop of a lot of these innovations. Another is Cali, based out of Chicago. And then the ABA Innovation Office, they're doing some of this. And then many legal services organizations, they even post on their website a lot of their triage tools and others. One that's really interesting to look at that you might not expect is Idaho. Check out Idaho Legal Services and the many tools that they have there. In North Carolina, I mentioned Kim Bart-Mulliken before. She and the NC State Bar hosted a hackathon at Campbell, actually, where legal services folks like Chris Cook and others came together with technology developers to develop legal tools. And there are a lot of those kind of hackathon things that go on. Various academic institutions, Duke, Georgetown, others host, like Iron Lawyer type of competitions where they're trying to build expert systems and other tools that help serve in certain areas. So there are places where this is happening. But to your point, Ashley, around there is that incentive. Also, if we said, it's certainly not a burden I want to put on North Carolina Legal Aid, right? Because they're already some of the, and I don't mean most underpaid for how important the work they do, and so busy, and every second that they take away to invest in a development of a tool is a second they're taking away from a real client knocking on their door at that moment that they would otherwise have to turn away. So their incentive not to innovate is different. It's that they care so deeply for every single person who's like with a name who needs services right now. It's the same thing in a clinic, right? You'd have to turn away those as soon as you devote time somewhere else. So I do think there are a lot of disincentives for legal services providers to low-income folks or to others to also to not invest this time. So, and they don't have money for the capital input sometimes as well. So I saw a hand from Mac.
Yes. Jeff, on the assumption that we can't solve every problem in the world in one committee, what do you think are the one or two most important things we could do on the tech front? Where would you recommend we head?
I'm glad you asked that. So on the tech front, I think we suffer amazing and threatening dearth of creativity and innovation in our legal service models. And so if you could do anything, it would be make it not only easier, but clear to the innovation and technology community that that we as lawyers are open to working with them, and that the regulatory space is safe for them to come in and start innovating in this space. I think even a little tiny, almost meaningless thing by comparison, like the Duke Law Tech Lab, as soon as we said, we're open to your ideas and willing to work with you, we have people flock to us from around, not just the country, around the world. We get applications from everywhere, innovative solutions. If we could send a signal to the innovation community that we're willing to deal with that level of innovation, I think we'd end up with some wins and some losses. But I think we have the capacity to deal with both, but we would end up with some really meaningful wins for the community moving forward. None of this at the expense of taking, no money should be taken from legal aid, no money, there should be no contraction in clinics. We should step up our pro bono, all those things are true. But to me, inviting innovation is the key. And 5.4 is the primary, 5.4 and UPL are the primary rules that deter those innovators.
Yeah, I don't know much about the tech. I don't know much about the tech community. How would we say that to that community? Simply make the changes in the rules and hope it got to them?
Yeah, and that's a great point, because I think there's been some fanfare about Utah by being a first, and they've benefited from the kind of social media and everything that happens around that. And they're, as a consequence, going to have people going there. I think even the way Arizona did it is probably not as effective, because they just kind of, with a whimper, pushed out something that said, hey, we're doing something similar and more stuff to come. I do think that's a concern. If you were to do it really, really well, I would try to tap the universities, the many great universities. I mean, NC State, for instance, has one of the best engineering programs in the country, and has a whole host of people who would be, and has a great design community, and all those things. It would be great. Public health at UNC, let me just point to other neighbors, possibly the best public health school in the country. Many of these legal issues are so intimately related to public health, they could do a great job attracting innovators, scientists, et cetera, who really understand the field and bringing them here. I think there's lots of ways to get the message out, Mac, with a bang, and say North Carolina wants to be on the front edge. But if we do it in a way that seems like a hem and a haw and wishy-washy, nobody's going to, who's talented, is going to pick their butt up from some chair, want to be here and want to invest a life in North Carolina, when we might turn around and say, yeah, we tried it for a couple of years and no big deal. We want to show a commitment, and want to show a supportive commitment. And I think that's the key.
Thanks.
Yeah, it's a good question, Mac. Thanks. Jeff?
Jeff, this
Yeah,
is
maybe
Warren.
just to,
Oh,
go ahead.
Jeff, you go. Jeff Kelly, go ahead.
Yep, just to piggyback on the question about how do we put it out there to the innovation community. I mean, there are some efforts and they are scattered, but we could definitely do a better job of combining them, where in the triangle, we have one of the biggest legal tech giants in the world in the form of LexisNexis. They have a 900 plus person campus on Centennial campus at NC State. And I can tell you that the interest, they did a hackathon when we could meet in person back, if y'all remember that, where there was about 160, I think, undergraduate students from all of the universities in North Carolina that came together, got a crash course in the legal system, and were basically just set loose to come up with a creative solution on a vague topic, which is the rule of law. So imagine a bunch of undergraduates who have had no context for this whatsoever, except for a few slide decks, and they go out and come up with the pretty wild solutions, but a lot of very creative ones in the span of a weekend. And I mean, I could see things like that as far as like getting attention, is coordinating with them on efforts. I'm sure that LexisNexis would be happy to have even more support for that initiative, but use that as not just a single event. And that's one problem I think we have as far as sustaining, and this is more on the sort of legal tech side of it, of sustaining the community involvement, is we have these big splashes and then we don't do much to continue to build on that. So that's one thing that, and I know that I'm preaching the choir in the form of Jeff and Camille, because they do have some of these programs that pick off that energy or continue to sustain the interest and support it, is that, I mean, we could probably do something as a committee that, even if we're not saying that it's a committee initiative, we could participate, we could invite that, and we could coordinate some of the conversation, or even if it's in the form of, we would give feedback on the problem to be solved or investigated, and just see what someone else comes up with and remain curious and involved and see where it goes. So there's a lot of different layers of commitment, but I do think that we have a very robust community here, that not just in the legal community, but the technology community, and a healthy overlap that's happening.
I don't want to take up all your time, but I know Warren, I think, were there other questions?
I'll go real quickly, Jeff. Is a sandbox, such as what Utah did, a way to make a positive statement that lasts for a while and collects data?
I'm very impressed with their approach. I think it has a few benefits. First of all, sandbox means temporary and testing. And so it can, some of the naysayers and some of those who oppose, it's a really meaningful way of saying that this is a trial. Another thing a sandbox does is it allows for there to be a key to entrance, and the key to entrance is a pledge to provide data. Very meaningful, bespoke, one-on-one data, that's meaningful. The other thing about the sandbox that's really important about Utah's model, and is absolutely essential, I think, is that upon exit, you are no longer temporarily approved, you are long-term approved and subject to the rule. And I think nobody's going to pick up and say, I'm going to invest all my time, energy, capital, et cetera, for a 2-year stint and then have somebody kick me out. I think upon approval, it needs to be long-term. And then the other thing about a sandbox that I think is really meaningful is that it allows them a window before they change the rules. So in other words, it's an alternative regulator. It's not changing the rules as written. It's saying, we're letting those in here who would otherwise violate 5.4 UPL, et cetera. And we're going to then come back to regulatory change, potentially. This is, I have nothing to do with it, so I don't know. But they can then come back with the information, data, and outcomes-based risk analysis that they've done with many different models, and maybe even some sharing with other states, to then see if there's a longer term change. So there is something really nice about that. It allows, on the one hand, for immediate action, but on the other hand, It doesn't open up the kind of legislative issues that Alice was talking about fully to full opposition without collecting data first. Well, I know.
One thing I think that you know, our committee could do is also how important it is to educate lawyers about these discussions. Many of us who are interested in this topic do tend to show up in the same places at the same events, but technology is just not a topic that grabs a lot of lawyers and that they want to participate in. But we have this mandatory technology CLE hour. So we have this wonderful opportunity where we could really share some of this information. And maybe something that we could do as a committee is to create a PowerPoint that a lot of different people could use. And we could kind of put on a road show or a webinar show that, look, there are people here who would be available and interested in going out and talking on this subject. And it could be members of our committee. We could partner with the bar, so maybe it was, Brian and Jeff Kelly, or, whatever our options are. But I think education is important. We could use the State Bar Journal as a way to start writing some articles. Even if we did things like highlight some of the programs that are happening at the Duke Law Tech Center, that's a nice sort of soft introduction to, law students, technology, enthusiasm. We could do some interviews with folks that would be interesting for people to read about, that people might not turn the page just because it's a technology topic.
Yeah, not to just really brief point, a real example of this is the pending artificial intelligence ethics inquiry. And I could see that as being a good opportunity to delve into something that is often talked about, rarely understood, and help contextualize existing ethics inquiries. So that's something, table that for another time, but that's I think a good opportunity.
Well, with my normal lack of social grace, I've overstayed my welcome. I apologize. I know we're at the end of the time, but I really appreciate you all letting me share time with you. And I'm happy to continue to connect and talk if there's any way that I can be helpful.
Thank you so much, Jeff. And we probably will be back in touch. I was going to say that one of the things that Mark Enriquez and Brian and I have talked about is getting somebody who has worked with the Utah program to really talk to us about what a sandbox looks like, and how they were able to get that approved. Now they, very big difference with both Arizona and Utah is that a lot of the stuff is driven by their Supreme Court. And we don't quite have that, but we certainly can find out, how they're doing it. And then look at, does that make sense? Is that possible in North Carolina?
Well, I'm in connection with a few folks, and I'm happy to connect you as well if there are folks we can. But one name just I'll throw out there, Lucy Rica is not only involved with the Utah and now the executive director of that sandbox, but also has been pretty intimately involved. She's from California, Stanford, worked with Deborah Rohde there, and also knows the California efforts really well. And so as a consequence, she has a little bit of a broader view than some of the others. And then of course, if there are other, that's I think for the sandbox, Ashley and others in particular, we're talking about some of this social phenomena about how people access resources. Cannot commend you enough the writings of Rebecca Sandifer as a sociologist who studies this issue. And so really fantastic in-depth stuff. So.
Great.
Can you say that name again, Jeff?
Yeah, Rebecca
Sandifer.
Sandifer, yeah, Sandefer.
She's an ABA fellow, research fellow, so you could access her stuff through the ABA website, I think.
That's right. There's also a really salient paper from Deborah Rohde and Jillian Hadfield from 2016 that's in the Hastings Law Journal. And if we're just, I can share some of these, but if we're talking about a few pieces that are really worth looking into, that one's quite good on different models that can work. And so it's not evidence-based in the way about what's going on the last couple of years in the United States, but it is a comparison different models that can be used. So.
Terrific.
Well, thank you.
Well, thank you, Jeff. I mean, I think this, one of the goals of this committee is to learn, and you've done a great job teaching us today and giving us a lot more to think about. So I thought it was a really excellent presentation and a great discussion. Thank you all for participating. As Alice indicated, I think, we've done a lot of education sections. I think my vision is we next start looking in a little more detail at some of the different proposals, things like a regulatory sandbox, limited license professional, and start scheduling those meetings where we can really dedicate a meeting to looking at some specific options, pros, cons, which ones are worth further analysis and some recommendations. So I think that's kind of a preview of what's else. Brian, Alice, anything else we need to cover before we conclude?
No, I think we're good.
Jeff again.
Jeff, thank you so much. That was just fantastic. It was challenging and engaging, truly.
Thank you. I learned as well. So thanks. Appreciate being a part of it.
Excellent. No, thanks again. Terrific job, and I look forward to talking to you all again in a month or so. We'll send around information about our next meeting. Enjoyed it. Thanks.
Mark, do you want Brian and I to hang on to talk about our next meeting?
Let's.
Okay. Thank you, everyone. It's good to see you.
Thank you.
In quotes. So that was great. I gave up trying to take notes. I just he talks so fast. I was like, well, forget that. But he's good. His PowerPoints don't tell you the whole story. They just give you the headline. So did we video it? Did we tape it? Oh, yay.
Wait.